Arranged marriages are becoming more common in the United States, based on many naturalized U.S. citizens being originally from countries that recognize arranged marriages, such as India, Pakistan, even China has arranged marriages. But arranged marriages have difficulty, including proving the bona fides of the relationship, which is not the same thing as showing that the marriage itself is entered legally. Typically, in arranged marriages, the fact that neither spouse have had a long relationship before with each other, or can show a history of knowing each other well, or a lot of correspondence going back and forth. Sometimes spouses can talk for 2 weeks before getting married, sometimes 5 days. Sometimes it's to a complete stranger. Arranged marriages are usually arranged by family members and not for necessarily reasons of love, but for reasons of a good match, for future children, for economic stability, for class reasons, or other reasons that have nothing to do with the romantic side of love. U.S. immigration still recognizes the validity of these marriages, but is most concerned, as it is with most all marriage cases, with the relationships formed for the purpose of obtaining a green card or for another reason. You can get engaged or married with a green card being a side benefit, but it cannot be the main reason why you're getting married. Arranged marriages can be more difficult to receive an approval from immigration because often marriages are entered into from a legal perspective first in order to start the immigration process more quickly, but then the couple does not live together until the religious wedding or ceremony that can last sometimes 3 to 5 days takes place, sometimes many months later after the green card application itself is filed based on the legal marriage. So when a couple doesn't live together because of the lack of the religious ceremony taking place yet, they are not living together very long prior to the green card interview and after the marriage, and immigration starts to suspect that maybe this is not a marriage that's bona fide based on a real relationship or one that's done for non-immigration purposes. There is also an inherent control element that often takes place in arranged marriages from an immigration perspective. The control of the immigrant visa based on marriage is always with the petitioning U.S. citizen spouse or permanent resident spouse. If she withdraws her sponsorship, the immigrant spouse can do nothing about it and would have to try to find a way to a green card through another route. Often in arranged marriages, the immigrant is unaware of the control the would-be in-laws have over the petitioning spouse, who is usually a younger person. In some cultures, the interference by the in-laws can result in a short marriage, quick divorce, and immense shame to the immigrant spouse, who may have difficulty remarrying ever again if they go back to their home country because of this cultural shame and stigma that divorce creates. Many arranged marriages are also conditional in nature from an immigration perspective because most immigrants are not engaged very long in an arranged marriage, and so the marriage itself happens within a matter of months, and the green card is only issued for a 2-year period. This is because if the marriage was less than 2 years old by the time the couple interviewed for the immigrant's green card at the local CIS office, then the conditional green card will be granted, a 2-year card as opposed to a 10-year card. This can also add complications to the relationship, especially if one spouse wants to take a job outside the state to pursue a career in the IT field or other computer programming or other dream job, but the in-laws are refusing to allow the U.S. citizen petitioning spouse to move with the immigrant because the in-laws do not want the immigrant and the spouse to move out of the in-laws' home. Keeping joint accounts open and active and putting each other on title of each other's property and seeing each other frequently can become very difficult in these types of cases when in-laws do not approve of a job placement or move out of the in-laws' home. And in many cultures, it is very standard for an immigrant to live with their spouse's family. But assuming that an immigrant benefits from an arranged marriage that actually turns out well, and the couple is happy and the in-laws are allowing the couple to commingle their assets, the immigrant and the spouse should focus on proving that they are residing together, have joint financial accounts, which they're actually using, and are putting their salaries into the shared account or paying bills from those accounts. Any pictures of activities and shared family outings can also bolster a showing of good faith marriage or bona fide marriage. And an arranged marriage, even if there isn't a track history of the relationship, can be approved in an immigration interview for a green card. In practice, arranged marriages usually have to provide more joint documentation than a typical marriage that is based on years of dating because there's more of a documented history, as the credibility of the relationship may be questioned despite the widespread cultural tradition of arranged marriages. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.